All right, we are about to jump into a really fascinating puzzle in the U.S. legal system, and I want you to think of this as a kind of constitutional detective story, one that's going to make you see a part of the Constitution in a totally new way.
So here it is, the central mystery. We all grow up learning about our fundamental right to a trial by our peers, right? The Sixth and Seventh Amendments seem totally clear on this, and yet, in federal court, some cases just don't have a jury. It's just a judge making the call. So how is that even possible? How can a juryless trial be constitutional?
Well, the key that unlocks this whole thing has to do with the law of the sea. It's called admiralty or maritime law. And you got to understand, this is a completely unique legal world. It's got its own rules, its own traditions, and a history that goes back way, way before the United States was even a country.
Okay, so let's start by laying out the pieces of this puzzle. Let's see exactly where admiralty law fits, or, where it doesn't fit the mold we're all used to.
Think about it like there are three main doors to get into federal court. Door number one is federal question, cases about the Constitution or federal laws. Door number two is diversity, for when people from different states are suing each other. You go through either of those doors, you get a jury. But then there's door number three, admiralty. And look at that. It is the one exception, no jury.
Now here's where it gets really interesting, because this shows us why admiralty is so different. See, the legal systems we know, the ones with juries, they're based on English common law. But admiralty law? Nope. It comes from a whole different family tree, the civil law traditions of continental Europe. It's a completely separate body of law. And that means the Seventh Amendment, which guarantees a jury in suits at common law, just doesn't apply to it.
To really get this, we have to jump in a time machine. Let's go back to, say, the 1770s. The American colonists have a huge problem, a major grievance that is absolutely fueling the fires of revolution. And it's all about a specific kind of court that had no jury. The colonists just despised the British vice admiralty courts. And can you blame them? I mean, look at this list. There was no jury of their peers. The judges, they were picked and paid by the king. So guess who they were loyal to? These courts were basically tools of the crown used to enforce really unpopular taxes and trade laws. And maybe worst of all, they flipped the whole idea of justice on its head. Merchants were basically guilty until proven innocent. You can see why they saw this as total tyranny. So this is the key thing to understand right here, the difference between two types of courts. Those old colonial courts were what we'd call Article I-like. They were created by the executive branch, the king, and they were completely dependent on him. What the framers of the Constitution wanted was the total opposite, Article III courts. These courts are a separate, independent branch of government. The judges have life tenure and their salaries are protected, so they can't be pushed around by politicians.
And this table just lays it all out perfectly. Look at the column on the left, the colonial tribunal. The judges serve at the whim of the executive, there's no jury, their power comes straight from the crown. That was the problem. The solution? It's the column on the right, the Article III federal court. Here, you have judges established by the Constitution, they have permanent jobs, and they have full judicial power. The framers' entire goal was to get from the left side of this chart to the right.
And this brings us to the climax of our detective story, the absolutely brilliant way the framers solved the problem of these tyrannical admiralty courts when they sat down to write the Constitution.
And here it is, right there, in Article 3 of the Constitution. The framers didn't get rid of admiralty courts. They didn't ignore them. What they did was they took that power away from the executive branch and planted it firmly under the control of the new, independent federal judiciary.
This is the genius move. See, the colonists' real beef with the vice admiralty courts wasn't just a no-jury part. It was the fact that the judges weren't independent. They were just puppets of the king. So, by putting all admiralty cases into these new, independent Article III courts, the framers fixed the main problem, the executive control, while at the same time preserving the ancient juryless tradition of maritime law itself.
And this new constitutional power covered the whole shebang, both traditional halves of admiralty law. You had civil admiralty, which handles all the private business disputes, things like damaged cargo, ships crashing, sailor wages, and then you had prize jurisdiction, which is the public side of things, dealing with ships captured during a war. Both of them were now under the authority of truly independent judges.
Okay, so let's connect all the dots. The Seventh Amendment guarantees a jury for suits at common law, but as we've seen, admiralty law isn't common law. It's its own separate system. So by taking this unique legal system and placing it inside the new independent judiciary, the framers hit two birds with one stone. They guaranteed fair trials, free from political meddling, and they kept a legal tradition that had worked for maritime trade for hundreds of years.
But what's really wild is that some of the unique and, what the colonists saw as harsher parts of Admiralty law didn't just vanish. They're actually still with us today, just in a very different context.
Check this out. Some of those reverse burden of proof rules are still on the books. So if you get in a car crash on land, the person suing has to prove the other driver was negligent. But in a ship collision at sea, if one of the ships broke a navigation rule, it's automatically assumed to be at fault. Same with damaged cargo. The shipping company has to prove they did everything right. The burden is on them.
But here is the all-important difference. While those rules might seem tough, the system that applies them today is fundamentally fair and constitutional. These rules aren't being used by judges who are loyal to a president or a king. They are applied by independent federal judges whose power comes straight from the Constitution. The framers fixed the system, not the specialized rules. Which brings us to the final question. Is this whole juryless trial thing in Admiralty law some kind of constitutional loophole, an oversight, or is it a deliberate, brilliant piece of design, born directly from the complaints that sparked a revolution? It really makes you think. It's a reminder that sometimes the most amazing solutions are hidden right there in the history. Thanks for joining me on this one.